Okay, this is file 22-21196-FC, People versus Andrew Olmhausen. We are here today for a pretrial in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Palapu.
Good morning, Your Honor. Melissa Palapu on behalf of the people, P74121.
Good morning, Your Honor. William Amadeo, P76194, on behalf of Mr. Olhausen. Mr. Olhausen appears via Zoom and consents to such. We also consent the Attorney General being on Zoom. Drew, please state the name for Judge Olhausen. No, it's you. Olsaver, I should say.
Andrew, nothing.
Say it again, Andrew, so you hear.
Andrew, nothing.
That is him, Judge.
Having a bit of a difficult time hearing him, but obviously that is Mr. Olmhausen. So Mr. Amadeo, where do we stand with Mr. Olmhausen's case today?
I do know that people want a trial date, Judge. The issue I have right now is we got a motion date for November 4th yesterday from your staff. There's some evidence that I'm not in possession of. When I went to view the alleged CSAM in Lansing, there were an array of text messages, I would say hundreds of text messages that Detective Keene did not put in the report. I believe this is exculpatory evidence. The text messages certainly contradict the timelines presented by Detective Keene. Detective Keene also told me on April 2nd that she deleted some evidence, apparently negligently. It's been 21 months, Judge, and I'm not trying to cast aspersions at the Attorney General, but I still do not have all my evidence. I need the evidence that is in the alleged CSAM. It needs to be bifurcated, and I need to make motions based upon that. I don't think I could proceed to a trial, but I have the whole complete bushel basket of evidence, which I still do not have. The Attorney General has expressed to me she's concerned that the messages I want are entangled with child porn. That's the concern. MSP told me they could bifurcate it. I really need those text messages that were not put in the report. They're crucial to my case. That's where I stand, Judge.
Your Honor, if I could just respond to that.
Yeah, go ahead.
Well, I don't necessarily agree with everything that Mr. Amadeo is saying. I do agree that there is a ton of evidence in the phone dump that I can't just pass over because there is a ton of images that could potentially be CSAM. Some of them are the charged CSAM and some are not. And so I just can't make a copy of this. MSP cannot bifurcate it. Maybe they told him that at some point, but I have asked several times. They can't do it because there's still the potential because of the thousands of things that are in this phone dump. As I'm sure you're aware, phone dumps are like so large and have so many data files in there. There's no way we can go through it all. So my proposal is, but I would need the court's permission to do it this way. My proposal is that we make a copy of the phone dump. I delete from that phone dump the images that we have listed. And then we have a special protective order for this for this phone dump that says that Mr. Amadeo cannot share or show anybody any image from this phone dump without getting written permission from the court or from the prosecution, with the image number being listed for what he wants to show. And I feel, and that no copies of this can be made, the general protective stuff that goes with it. But I feel like that's a way where we can ensure that if there is CSAM that is inside of this phone dump that we just don't know, we don't see, that it's not getting copied, it's not getting given to anybody else, it's not getting shown to anybody else. Mr. Amadeo would be protected by this protective order. We would be protected by this protective order in case there was like CSAM that was mixed in there that we couldn't see. And then he could get all of that other stuff as well. I know it's a little bit odd and I know it's a little bit contrary to the CSAM statutes, but I think that it's the best way to get it done. And I mean, I trust that Mr. Amadeo wouldn't be running around making copies of the CSAM. And I just feel like this is the best way to protect us all in case there is CSAM mixed in with all of those hundreds of thousands of data dumps.
And if I may briefly respond to that.
Go ahead.
On July 8th, I did speak to Trooper Kyra Tekowski. I drove 82 miles to meet with him at the computer crime unit. He told me under no uncertain terms this evidence could be bifurcated and I could have it. I did contact the Attorney General after that meeting. I know she was on vacation. I do believe it can be bifurcated. I have no doubt that Ms. Pelican is trying to do the right thing here. If she wants to do this, I would need to meet with her respectfully, Judge. I'm not going to put them on the honor code after what Detective Keene told me she already deleted evidence. So I'd want to be there for that process if that's where we're going. If she's going to delete things and then hand it over to me, I want to see what's being deleted. There's critical text messages that I need for this case, Judge.
And respectfully, I am not going to be waiting around for Mr. Amadeo's schedule to do this. I would send this request, I would send the protective order to get signed, and then I would send it to MSP to do, and I would put him on the email chain to say the things that needed to get removed from it, and then I would get it done quickly. I am not available to go and meet with anybody and do this request until October, and I don't want to delay things anymore. I just want to get this case tried.
And Your Honor, I don't want to delay things either. I've been trying to get evidence from the people for 21 months. If I'm not available, I'll send Scott Grable from my firm. As long as somebody's there to represent Andrew Holdhouse and to make sure he gets the evidence which could potentially exonerate him, I have no problem with that. I'll work around Ms. Pelican's schedule.
But again, because the images that we would pull up to delete are CSAM, we can't just have anybody in the room to verify the CSAM.
Well, if it's an associate from my firm, actually the owner of my firm who's going to try to case it, man, I don't think that'd be an issue, would it?
I mean, the issue is I don't have time to be waiting around for somebody to come to meet with my
All
schedule.
right, so Ms. Valbu, I'm going to just interject here at this point because I've heard enough of the back and forth. If we need to make time, we're going to make time because we're going to do this the best way that we can do this, given the circumstances, which are difficult. So that's how we're going to proceed forward from here. Mr. Amadeo, is the solution that Ms. Halapu outlined agreeable to you, assuming that you can be there to see what is being deleted?
Absolutely, Judge.
So then we will just do it next week.
Okay, I'll have Scott Grable there if I'm in trial. Please let me know when next week and where. I'll make sure someone's present.
I'll send an email to MSP with you and they'll set the day and time.
And I will have Scott Grable copied on it to be present for everything.
How much time do we need to try the case?
I would say it's a pretty typical CSE case. I would say a week.
I think 5 days is appropriate.
All right, Ms. Clark, can we need a 1 week trial? So Mr. Amadeo, so does what we've discussed today resolve your November 4 motion?
No, it does not, because what I'm gonna have in there, it can destroy the timeline and the elements for them. From what I get there, Judge, that has to make my motions.
Okay, so it has to be sometime after November 4.
Correct. It may be dismissed or remanded based upon what happens with these motions. That'll be your call, obviously, Your Honor, but there's some of the motions I planned already.
Tuesday, January 2nd or January 7th at 9 a.m. January 8th at 10:30, January 9th at 9 a.m., January 10th at 9 a.m. And then Tuesday, January 14th at 9 a.m.
Thank you. We'll make that work.
Do those days work for the people, Ms. Palku?
They do, Your Honor. Thank you.
Right, the court will issue a scheduling order with those dates in it and some additional information about jury instructions and voir dire and other logistical issues. Is there anything else that we need to address for today?
Not from the defense, Judge, thank you.
The only thing is that we had previously made an offer and I had told Mr. Amadeo that I needed to just put on the record that we were pulling the offer because the offer was for Mr. Olmhausen to plead to 1 count of CSC first degree, 1 count of CSC second degree, 1 count of CSAM possession, and 1 count of contributing to the delinquency of a minor, with a sentence agreement of 20 to 30 years in the Michigan Department of Correction, SORA registration, and lifetime electronic monitoring. I do understand that Mr. Olmhausen does not want to take that offer, and I completely respect his decision. So I just wanted to put on the record that we are withdrawing that offer.
I thought the offer was already withdrawn. No problem with that, Judge. Thank you.
All right. Sorry, we're also going to need a final pretrial date, so let me. How about December 18th at 8:15 for a final pretrial?
That works for the people, Your Honor.
So what's that date, Judge?
December 18th.
15 year.
Correct.
Peter, thank you, Judge.
All right, thank you.
Thank you, Your Honor.
Mr. Olmhausen, you can go ahead and log out.
Okay, thank you, Your Honor.
Okay. I don't know. The only ones they showed me.
Yeah, he's not. Okay. Mr. Daly, are you ready to proceed with Mr. Levi?
Yes, Your Honor. But I don't see Mr. Levi.
It is on Zoom. He should pop up on the screen in a minute. Mr. Levi, can you hear me?
Yes, Your Honor, I can hear you.
It is file 24-21875-FH, People versus Eric Brian Levi. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. McClure.
B.B. McClure on behalf of the people.
James Daly on behalf of the defendant.
All right, and Mr. Daly, where do we stand with Mr. Levi's case today?
Your Honor, there has been a plea bargain offered in Mr. Levi's case, which I believe is appropriate for the case. My problem is I have not been able to get Mr. Levi in to discuss the offer. I have been able to talk to Mr. Levi on the phone. The only time that he will answer a phone call is if you happen to catch him while he's using a computer. So I believe we are ready to enter into an agreement in this matter. I haven't had a chance to talk to him yet. I'd like to talk to him. I'd like to make arrangements to take the plea. But I'm reluctant to do that without having had any opportunity at all to talk with Mr. Levi, even though we've been trying to get a hold of him all week long.
All right, Ms. McClure, is there anything we need to address from the people's side?
No, people in no position.
All right, what I'm going to do is adjourn this to August 28th. That's 2 weeks from today. Mr. Levi, are you still able to hear me?
Yeah, yes, Your Honor.
Okay, you need to call Mr. Daly's office right now as soon as you log out of here and make an appointment to go in and see him or talk to him on the phone before August 28th.
Okay. I'm actually gonna Adrian today if you'd like me to stop by today.
Does that work for you, Mr. Daly?
I'll be in Ann Arbor.
Okay, all right.
All right,
Okay, I'll call his
you need
office.
to make an appointment.
Yes, Your Honor.
Thank you, guys.
All right, Mr. Daly, you do a stipulation in order for that dismissal.
Yes,
I'm
sir.
sorry, dismissal, adjournment.
I'll prepare you, all right.
Thank you. Mr. Levi, you can go ahead and log out. Your next date is August 28th at 8:15.
August 28th at 8:15. All right. Thank you, Your Honor.
Thank you. All right, the gentleman just logged into the Zoom session. I need you to unmute your device. And can you tell me your name, sir?
Mari Jones.
All right, Mr. Bennett, do you need to speak to Mr. Jones?
I do not, Your Honor.
All right, this is file 23-21616-FH, People versus Maurice Leroy Jones. We are here today for arraignment on a bench warrant related to bond conditions. Sir, you are Maurice Leroy Jones, correct?
Yes.
Did you receive a copy of the warrant, Mr. Jones?
No.
All right, Mr. Bennett, have you received a copy of the warrant?
I have not, Your Honor. The court, I believe, read the warrant last week. I'm familiar with the contents. If the court could email it to me, I'm prepared to go forward.
All right, we will email you a copy, Mr. Bennett. While we are doing that, I will just say again for the record that the warrant alleges that Mr. Jones violated his bond conditions by testing positive for cocaine in the drug screen collected on July 30, 2024. Maximum possible penalty for contempt of court is up to 93 days in jail or $7,500 in fines. Mr. Bennett, do you know how Mr. Jones wants to proceed today?
Your Honor, Mr. Jones would like to plead not guilty to the allegation.
All right, so I'll enter a not guilty plea for Mr. Jones. And we have this set for, the underlying case set for a trial date. Is that correct, Mr. Bennett?
Yes, Your Honor, for August 20th.
August 20th, okay. All right, so we'll set the contempt for August 20th as well. And we'll deal with it at that time.
Thank you, Your Honor.
All right, so thank you. Is anything else we need to address on this today, Mr. Bennett?
No, Ms. Arnold may be reaching out to your office for Cobb's evaluation. That's the only, and other than that, I think we're both preparing for trial.
All right. And just so we're clear, I did speak to Mr. Coast this morning. It's my understanding that Mr. Jones is going to be testing directly with Mr. Coast at this point, rather than through the drug testing facility.
Yes, Your Honor, Mr. Jones understands that. Actually, he informed me of that immediately upon it posting his bond.
All right, I think we're all set for today then. Mr. Jones, you can go ahead and log out.
Thank you.
Thank you, Your Honor.
Okay, we can do remaining minutes. This is file 24-21714-FH, People versus Jesus Joseph Moreno. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Awuta-Coker.
Good morning, Assistant Attorney General Emmanuel Awuta-Coker, on behalf of the people.
Ron Underwood on behalf of Mr. Moreno this morning, Your Honor.
Is Mr. Moreno present in the courtroom? All right, record should reflect this matter was set for a pretrial conference this morning at 8:15 a.m. Mr. Moreno was required to be here for that pretrial hearing. He is not present in the courtroom at this time. He is not logged into the Zoom session. I have identified everyone that's in the waiting room. Ms. Underwood, anything you want to say with respect to Mr. Moreno?
I have no information as to Mr. Moreno's whereabouts at this time, Your Honor.
All right, looking through the file, I don't see any previous failures to appear by Mr. Moreno, so I will give him the 48-hour grace period. If he's not contacted the court in that 48-hour grace period, I will at that time revoke and forfeit Mr. Moreno's bond and issue a bench warrant for his arrest. I would set bond on the bench warrant in the amount of Mr. Awuta-Coker, what's the outstanding payment that Mr. Moreno has for child support?
His current arrearage is $13,484.
So I'd set bond at $13,484.
Thank you, Your Honor.
Mr. Glazer, Mr. Hartshorn, are you ready with Mr. Taylor?
Yes, sir.
Yeah, ready, Mr. Taylor. Okay, we are on the record in files 19-19313-FH, 19-19314-FH, 19-19315-FC, 19-19367-FC, and 19-19433-FH. People versus David Curtis Taylor. We are proceeding today in person. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Hartung.
Good morning, Mayor. Doug Hartung, appearing for the people today.
John Glazier on behalf of Mr. Taylor.
All right, and Mr. Glazier, where do we stand with Mr. Taylor's case today?
Your Honor, my client's going to enter some pleas today. The prosecutor has indicated that the charges he's going to plead to, that I guess it'd be a cops or killable, excuse me, they'd run concurrent. The sentencing would be at the low end of the guidelines.
All right, I'm sorry, go ahead.
In regards to file number 9433FH, he is going to plead to accessory after the fact with the understanding that habitual offender be dismissed. On file number that ends in 9315FC, he's going to plead to count 7, carrying a weapon with unlawful intent, and to unarmed robbery.
Just count 11.
Count 11, excuse me. And on file number 9367FC, he's going to plead to count 12, unlawful imprisonment. I think that's it.
That is correct.
The 367 file is kind of unlawful imprisonment.
Just count 12.
Okay, was there? Did an amended information get filed?
Should have been emailed to you, but you can certainly use mine right now. Mr. Glazier has a copy. Would you like to see mine?
Oh, okay. Yeah, if you don't mind.
The other one is the 315 file also has an amended info, so I'll hand those to you. These are highlighted.
Thank you.
I don't know if I stated yet, but habitual be dismissed on all those funds.
Okay, is that accurate, Mr.
Yes, the balance of the counts that weren't outlined by Mr. Glazer will all be dismissed as sentencing along with the habituals.
Mr. Taylor, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are David Curtis Taylor, correct?
Yes, sir.
Mr. Taylor, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention in file 19-19315-FC to plead to count 7, carrying a dangerous weapon with unlawful intent?
Yes, sir.
Do you understand that the maximum possible penalty for that offense is up to 5 years in prison or $2,500 in fines?
Yes, sir.
Is it also your intent in that file to plead guilty to count 11, unarmed robbery?
Yes, sir.
And you understand that the maximum possible penalty for that offense is up to 15 years in prison?
Yes, sir.
In file 19-19367-FH, is it your intention to plead guilty to count 12, unlawful imprisonment?
Yes, sir.
And do you understand that the maximum possible penalty for that offense is up to 15 years in prison and or a $20,000 fine?
Yes, sir.
In file 19-19433-FH, is it your intention to plead guilty to count 1, accessory after the fact to a felony?
Yes, sir.
And do you understand that the maximum possible penalty for that offense is up to 5 years in prison and or a $10,000 fine?
Yes, sir.
Are you satisfied with Mr. Glazer and the advice that he's given you?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here today. Is that correct, Mr. Hartung?
That is correct, Your Honor.
Mr. Glazer?
That's correct, Your Honor.
Is that also your understanding, Mr. Taylor?
Yes, sir.
If the guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you were guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Taylor, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, sir.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
You understand that you're giving those rights up?
Yes, sir.
How do you wish to plead in file 19-19315-FC to charge that on or about January 26, 2019, in the city of Adrian, county of Lenawee, that you did commit the offense of carrying a dangerous weapon with unlawful intent?
Guilty.
And how do you wish to plead in that same file on January 26, 2019, in the city of Adrian, county of Lenawee, that you did commit the offense of unarmed robbery?
Guilty.
And in file 19-19367-FC, how do you wish to plead to the charge that on or about February 3, 2019, in Raisin Township, Lenawee County, Michigan, that you did commit the offense of unlawful imprisonment?
Guilty.
And in file 19-19433-FH, how do you wish to plead to the charge that on or about January 21st, 2019, in Medina Township, Lenawee County, Michigan, that you did commit the offense of accessory after the fact to a felony?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No, sir.
You understand that if I accept your pleas, you'll be giving up any and all claims that those pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter those pleas?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Taylor to plead guilty today?
No, Your Honor.
No, Your Honor.
Mr. Taylor, other than as we've discussed on the record this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, sir.
Is it your own choice to plead guilty today?
Yes, sir.
Mr. Glazier, do you want to cover the factual basis?
Yes, Your Honor. David, starting with file that ends in 315 FC, it indicates an honor about January 26th of 2019 that you were carrying a weapon with the intent to use it unlawfully, either to use it against someone or to defend it against anything. You understand that?
Yes, sir.
Count 11 in the same file says there was also an unarmed robbery that occurred on that occasion. And is it true that that you, using force, stole from a Mr. Brandon Albright, an Xbox, marijuana, pellet, gun, cell phone, but by using force? Is that correct?
Yes, sir.
All right. The next file ends in 9367 FC. And on that one, you're pleading guilty to count 12, which is unlawful imprisonment. And this says that on or about February 3rd of 2019, that you imprisoned a Brandon Inger using a weapon or a dangerous instrument, restrained him and wouldn't let him go any places, basically, with the same section.
Yes, sir.
That's what it says. Is that not right? Hold on a second. Here it is. Are you sure that's the Judge?
That's how she put it, Judge.
Yeah, but my client's not sure that's the name, but he would agree
Yeah.
that he
It
did.
was Brandon. I just don't know the last name.
So the Latin first name is correct.
Okay.
Okay, and Brandon somebody, it may not have been, he doesn't think the last name was Inger, but he did falsely imprison
Yes,
somebody.
yes.
Is that
Yes,
correct?
yes, sir.
With the name Brandon?
Yes, sir. I just think the spelling's wrong.
Okay. The last file that ends in 4 through 3 FH is an accessory after the fact to a felony. And in this case, we're talking about the felony charge of homicide or open murder. And I believe the defendant was Austin Richardson in that case. Is that correct?
Yes, sir.
In that case, you, if I remember right, at some point you had the weapon and helped dispose of it. Is that correct?
Yes, sir.
And that was to mislead police at that time. Is that correct?
Yes, sir.
I don't have any other questions.
Mr. Hartung?
I do have a couple of questions. Mr. Taylor, on the carrying with dangerous weapon charge, the first one that Mr. Glazer had to discuss, what was the weapon you had on that occasion?
The same weapon as the murder weapon.
So it was a handgun.
Yes, sir.
And the armed robbery that the unarmed robbery that Mr. Glazer outlined for you in that plea, that was successful. You were actually obtaining the items from that man by use of force or threat.
Yes, sir.
And the unlawful imprisonment, what was that based upon? Why were you unlawfully imprisoning that man that day? The other charge.
For robbing.
You were holding him in a position so that you could complete the robbery.
Yes, sir.
That was against his will.
Yes, sir.
And you had a weapon at that time too?
Yes, sir.
Same gun.
Yes, sir.
Okay. And the last charge that Mr. Glazer went through, the accessory after the fact charge, That related to the murder of Chris Dickerson, is that correct?
Yes, sir.
And after that murder had been completed, you had the handgun in your possession,
Yes, sir.
and you used it in those other items that you talked about, other incidents you talked about, is that correct?
Yes, sir.
And ultimately, what became of that weapon?
I don't know. I don't know what happened to it. It got sold somewhere. I just don't know what happened to it after.
Thank you. I have no further questions.
Has the court complied with MCR 6.302 B, C, and D? Mr. Harkam?
Yes, Your Honor.
Mr. Glazer?
Yes, Your Honor.
I will accept the pleas then. They've been given understandably, voluntarily, and accurately. Mr. Taylor has had full knowledge of his rights and he has had competent counsel. The court has not made any agreement regarding the possibility of plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as it's been stated on the record here this morning. I will refer this matter to the probation department for a pre-sentence investigation. And we'll set sentencing for September 26th at 8:15 a.m. Mr. Taylor, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. Do that interview. Please be truthful about these offenses and about your background. Is there anything else we need to address in these files today, Mr. Attorney?
Oh, Your Honor, I'm sorry. I apologize. One of the victims' representatives in this case will not be available on September 26th. Is it possible to change that?
Yeah.
Your Honor, my client had a request. He wanted to know if he would have permission to send a letter of what? Or read in court to Mr. Dickerson's family. Or he may read it in court, I guess.
So he'll have an opportunity to make a statement or allocution before the sentencing. So, all right. So we needed a date. So September 26th did not work. How about October 3rd at 8:15?
That works.
October 3rd at 8.
That'll be fine.
Anything else we need to address today?
No, you're.
Oh, yeah, thank you.
Thank you.
Sorry, Ms. Holly? Ms. Holly, your audio is not, we can't understand what you're saying. No, it sounds like you're talking into a tin can. Can you send me your question in the chat?
Yes.
Mr. Hartung wants to do that. You want your information?
I can take it back. Would you like me on for your file?
If we've got an email, we'll take clean copies because
Okay.
they're marked up.
Thank you.
Okay. Okay, so Ms. Holly's question was about the other two cases on the docket. So those are going to be dismissed, Ms. Holly, at sentencing. All right, so I think we're all set then.
All right. Thank you.
All right, Mr. Woolley, do you want to come forward, please? Okay, this is file 23-21329-FH, People versus Javius Tremaine Woolley. We are here today regarding a probation violation, alleged probation violation. We are proceeding today in person. Sir, you are Javius Tremaine Woolley, correct?
Yes, sir.
All right, so Mr. Woolley, when you were last before the court, you had indicated that you had an ability to hire your own attorney to deal with the probation violation. Have you been able to speak to anyone or hire an attorney?
I feel like in this case, I wouldn't have to need to hire one. So I would just like a court appointed one, if that's okay.
Okay, so do you have the ability, the financial ability to pay for your own attorney?
I'm waiting on workers' compensation right now. So I do, but I don't, if that makes sense. I haven't gotten paid yet, so.
Okay, so are you currently working right now?
Like, I'm employed through Tenneco, but I'm on workers' compensation because my finger's gonna get amputated. So I haven't gotten paid yet.
So you're not actually going to work each day, is that?
Yeah, like I have to go to the emergency room right after this.
Okay. And so right now, other than waiting for your workers' compensation, do you have any other source of income? Okay, so I'll have you speak to the public defender. Our public defender who would handle probation violations has logged out of my court. She's going to Judge Anzalone's court. So what I am going to do, did you have a trial or something scheduled in Hillsdale?
Yeah, I gotta go straight to court in Hillsdale right after this as well.
Okay. And is that a trial or they're just still setting?
That's a preliminary examination.
Okay.
I have the paperwork right here if you want to see it.
All right, so what I'll do is I'm going to adjourn this to September 4th at 8:15. So September 4th at 8:15 a.m. In the meantime, I will appoint the Public Defender's Office to represent you. You're going to need to get in contact with the Public Defender's Office, set up a meeting with Rhonda Underwood in order to, discuss the situation with her and, figure out what you're going to do next. Okay.
Yes, sir.
All right. So you are all set for today. Then again, your next date is September 4th at 8:15 a.m.
September 4th.
Correct.
All right. Thank you, sir.
Thank you. All right, Mr. Goldstein, are you there?
Yes, Your Honor.
Okay, are you ready to proceed with Mr. Gehring?
If Mr. Gehring is present, yes, Your Honor.
Yeah, he is in the courtroom and making his way to the podium right now. Okay, this is file 24-21768-FH, People versus Roger Lee Gehring. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. First, let me have the attorneys place their appearances on the record, beginning with, we have lost Ms. McClure. All right, so we don't have a prosecutor at the moment, so we will resume once we have, oh, no, there's Ms. McClure. Ms. McClure, right there? All right, so apparently Ms. McClure stepped away from her desk for a minute, so we'll resume as soon as she gets back.
Okay, I'll be standing by.
Okay, thank you, Mr. Goldstein. Mr. Daly, Mr. Amadeo, and I'm sorry, Assistant Attorney General, I've forgotten your name. What's your
I'm sorry, Your Honor. Benita Hoffman,
Okay, could you approach, please?
certainly. Yes, Your Honor.
I have Richard, and he is where? He's in Washington. We don't have much on.
I can get involved in them. I'm not worried about it. I'm in Washington anyway.
Okay,
So I go see it today.
so you,
But I know one of the code offenses I think that,
yeah,
I need a motion based on that before we go to trial. So I just get a trial date for my guy.
but you don't need his presence.
No, I can wait his presence.
Okay, I will, I'll call our jail. You have Ricardo.
That he has Michael. I have
Yeah,
Michael.
Michael, okay, so I will call, he's at.
I'll wait his presence on the record, so there's no issue.
Okay, all right, so we can call for
Thank you,
Michael.
Your Honor. I do have an amended information to present to the court.
Okay, you got it.
Thank you.
You going to be coming over?
You want him here in person?
Excuse me. It's just a part.
It may go better at silence. Nervously, I don't know. I mean, I was in talking to him yesterday, but I know he was planning on being there.
Okay. I don't. think he's on the jail list for some reason this morning,
Because
so
you set it over for a week.
we'll call, we can call and see if they can bring him.
This is the attorney agreement, but he is not signed yet.
Okay.
Do you want to send over for a week just to make sure you sign he's on board or not?
Well, he's on board.
Okay. But he didn't sign it yet. Yeah, okay.
But he'll admit.
Why don't you keep this then if he hasn't
Okay.
signed it, and then we'll, once he.
Yeah, he
gets
wants
signed.
to do the deal.
Could you just put on the record if he's going to
Yeah.
take the deal? Judge, if they want to put on the record, he's going to take the deal. Like, I know you got a busy docket. I could tell my guy if he's taking the deal next week, get a trial date from there, if you need him here, if that's an issue.
I'm sorry,
If you need Michael here, like he wants, and you want to put on the record that he's pleading next week, I have no issue with that. If you want to wait for him to come, I think Mr. Daly wants him here. My guy, I'll waive his press. I have no issue with that. So it's whatever you guys want.
all right.
I'll relay to my
Let me see
client.
what we can do with the jail if we can get,
If you want him here.
Thank you, Your Honor.
I don't care either way. Let me know.
Okay.
I said, I thought my guy was going on.
all right, Ms. McClure, are you there? Okay.
Yes, I am now.
Okay, so we can proceed with file 24-21768-FH. People versus Roger Lee Gehring. Ms. McClure, do you want to place your appearance on the record?
BB McClure, up the people.
David I. Goldstein appearing on behalf of the defendant.
Okay, and so Mr. Goldstein, where do we stand with Mr. Gehring's case today?
Your Honor, Ms. McClure, on behalf of the people, made an offer that if my client pled guilty as charged to the charge of possession of controlled substance, that the sentence in this matter would be a probationary sentence under 7411. And I believe he is going to avail himself of that offer.
Okay, so it looks like we need an amended information for that plea.
I have prepared one. I can forward it at this time.
Okay.
And I think we forwarded a plea agreement as well.
I do have a copy of the plea agreement.
Okay.
Okay, so Mr. Gehring, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury? I need you to speak up louder than that.
Yes, Your Honor.
All right, so Mr. Daly and Ms. Hoffman, Mr. Daly and Ms. Hoffman, if you need to speak, can you step out into the hall? It's a little too loud for trying to continue here. I'm sorry, sir, you are Roger Lee Gehring.
Yes, I am.
Mr. Gehring, you've heard the statement of your attorney and the prosecuting attorney is that your intention to be guilty today to attempted possession of methamphetamine.
Yes.
Are you satisfied with Mr. Goldstein and the advice that he's given you?
Yes.
You understand that the maximum possible penalty for that offense is up to 1 year in jail and or a fine of $2,000.
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here today. Is that correct, Mr. Goldstein?
That's correct, Your Honor. I think
You are muted, Mr. Goldstein.
There it goes. Yes, Your Honor, it's correct.
Okay, thank you. If
Your
guilty,
Honor, I'll cut you off 1 second. Your Honor, when you were stating the maximum possible penalty, if I heard you right, I thought I heard you say 1 year. I don't believe that's correct. The amended information I have indicates that it's 10 years.
And actually, the amended information isn't correct either. It should be 5
Right.
years.
Should be 5, exactly.
Yeah, I don't, the
Yeah.
amended information also says count 3 and count 4. I don't know why, so I'll have to fix that. I'm sorry. I don't know why it says that. But it is 5 years.
I agree with
okay,
that.
I apologize. Mr. Gehring, you understand I was incorrect when I said earlier that the maximum possible penalty was up to a year in jail. Maximum possible penalty for this offense is actually up to 5 years in prison. Do you understand that?
Is that what you told me, Mr. Nelson?
I'm sorry?
Is that what you told me?
No, I told you 10. It's actually 5. I made a mistake just like Ms. McClure did, or whoever typed the information did. It's a 5-year. But you have an agreement for probation under 7411, which is the first offender program that we discussed.
Okay, that's what I thought was what we discussed.
Yeah, that's what the agreement is. But the judge has to tell you what the maximum possible, he's required in any case to tell you what the maximum possible penalty is.
Okay, I didn't know that.
Okay.
All right. So do you understand that now, Mr. Gehring, that the maximum possible penalty is up to 5 years?
Yes, I do.
All right. If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Gehring, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, I'm just going by my attorney's, what I talked with him about.
Okay, but I need you to understand that that if your plea is accepted, you may be giving up the right to appeal issues that you could appeal if you were convicted at a trial. Do you understand that?
Yes, I understand.
You understand that you're waiving that right?
Yes, I understand.
You also understand that any appeal from your conviction and sentence pursuant to this plea would be by an application for leave to appeal and not by right.
I really didn't understand what that.
Okay, so an application for leave to appeal means that you're asking the Court of Appeals to hear your case and they can say yes or no. An appeal by right means that the Court of Appeals would have to take your appeal if you wanted to appeal. Since you're pleading, you would only have an application for leave to appeal, meaning the Court of Appeals could hear it or decide not to hear it, instead of having a right to appeal, which you would have if you were convicted at a trial. You understand that you're giving up that right to an appeal, and it would only be by an application.
I understand.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of your rights?
No.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead then to the charge that on or about November 19, 2023, so Ms. McClure, do you know the city, township, or village? Mine just says Lenawee County.
It should be Adrian Township.
All right, so how do you wish to plead, Mr. Gehring, to the charge that on or about November 19, 2023 in Adrian Township, Lenawee County, Michigan, that you did commit the offense of attempted possession of methamphetamine or ecstasy?
Well, me and my lawyer discussed.
Okay, so if you want to plead guilty to that offense, you need to say guilty.
Okay, yeah, guilty.
I'm sorry?
Ain't that what you said? Yes.
Yes.
All right, has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter that plea?
Yes.
Is the prosecutor defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Gehring to plead guilty?
No, Your Honor.
No, Your Honor, but before we go any further, since the information is going to have to be retyped anyway, the date of offense on the information is incorrect. It says 11/19 of 23. That was the date that the search warrant was signed. The search warrant execution, which led to this charge, was actually November 21st of 2023.
I had already retyped the information, but I can correct
I mean,
it.
on or about stretches, but I don't want to stretch too far, Judge.
Yeah. I can correct that.
Mr. Gehring, other than as we've discussed it on the record today, has your attorney promised you any particular sentence or estimated what your sentence would be?
He told me what it was, what they recommended, the prosecuting attorney.
Okay, has he said anything other than what we've talked about on the record today, which is that you would receive probation under the 7411 program?
That's what he told me.
Okay. Is it your own choice to plead guilty today?
Yes, because I mean, that's what we discussed and that's what he said.
All right. Mr. Goldstein, do you want to cover the factual basis?
Yes, Your Honor. Mr. Gehring, on November the 21st of 2023, were you at a location of 8418 South Adrian Highway in Jasper, Michigan?
Yes.
And is that in Lenawee County, state of Michigan?
Yes.
And at that time, did you have in your possession some methamphetamine or some ecstasy?
Yes.
Okay. And you knew or you believed it to be ecstasy?
Do what now?
Did you know it to be ecstasy or did you believe it to be ecstasy?
No, I didn't know.
Okay, did you believe it to be ecstasy?
Judge, as far as I know.
Okay. Did you have a license or permission to have that ecstasy?
No.
Okay, I'm satisfied, Your Honor.
All right,
Satisfied,
Ms.
Judge.
All right. Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Yes, Your Honor.
Scholes? All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Gearing's had full knowledge of his rights and he's had competent counsel. Court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than as we discussed on the record here this morning. I will refer this matter to the probation department for a pre-sentence investigation, and we'll set sentencing for September 19th at 8:15 a.m.
Your Honor, I'm going to be out of the country on that date.
About September 26th at 8:15 a.m.
Your Honor, would it be possible to go to the following Thursday, the 3rd of October?
So October 3rd at 8:15 a.m.
Thank you. The 26th is the day I get back from my trip, and I'm probably not going to be in very good shape physically. So,
Understood. All right. So Mr. Gearing, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background. So let's see, Ms. Holly, are you there?
Yes, can you hear me?
Okay, I can hear you better now. So
Okay.
what I'm going to do, so Mr. Gearing is here in the courtroom. Do you want me to have him just step across the hall to the
Yes.
probation department?
Yes,
Okay.
please. Thank you.
Okay. So Mr. Gearing, when you leave the courtroom, go straight across the hall to the probation department. They'll have some information for you to pick up, and they'll get your contact information from you. Okay.
Okay.
All right. So you are all set then.
All right, thank you.
Thank you. Okay, Mr. Dagger Margosian, are you there?
Yes, Judge.
Okay, I don't believe, is Mr. Felton here? Don't believe we have Mr. Felton here. Do you want me to call the case or do you want to try to contact him?
Well, I did try to contact him earlier. I was unsuccessful. We can call the case and I can put my argument on record.
Okay. All right, this is file 23-21654-FH, People versus Cody James Felton. We are here today for a pretrial conference in this case. We are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. McClure.
E.V. McClure on behalf of the people.
Your Honor, Michael Dagger Margosian for Mr. Felton.
All right, and so record should reflect that Mr. Felton had a pretrial this morning at 8:15 a.m. It's now 9:30 a.m. Mr. Felton is not present here in the courtroom, and he is not logged into the Zoom session. Mr. Dagger Margosian, is there anything you want to say with respect to Mr. Felton?
Your Honor, as I was alluding to off the record, I did try to contact Mr. Felton at the phone number I have listed. It was unsuccessful. In the past, it has been somewhat difficult getting a hold of him. I think just because he does live on the west side of the state. And I think his phone situation sometimes is in flux. He has been in court, I think for pretty much every court hearing, and as the court may or may not be aware, the case will be resolved by way of fines and costs once he just gets a certain amount of money together to pay the restitution. With all that being said, I think I would be asked if the court would be in agreement. And I know that I think we've gone before on this case, and I think Ms. McClure may be bringing this up in a second. But I would be asking for an adjournment of the pretrial rather than any sort of show cause or contempt, just because of, again, this case, how this case is going to be resolved and the nature of it and his situation. And I guess lastly,
Go ahead, Mr. Dagan.
I guess lastly, what I'll say, Judge, obviously, if he does not show a second time in a row, then certainly the court would take a different position.
All right, Ms. McClure, anything from the people's side?
The only thing I would add is that he, back in February, had failed to appear. And when we adjourned it in lieu of a bench warrant, at that time, he did appear the next date. But just to make a note that he has done the same thing in February. And then also in a previous fail to appear, he was in Calhoun County Jail. So I don't know if we need to check there for him or something like that, but you know, it's not the first time this has happened. I'm not opposed to an adjournment, but I want to make sure we have a good address that he can get that notice so that we have a leg to stand on to do a bench warrant next time.
All right, so what I'll do is adjourn to August 28th at 8:15 a.m. Mr. Dagan, would you do that stipulation in order?
I will, Your Honor.
Okay, thank you. I think you also need to express to him at this point that we've accommodated him on a couple of occasions now, and there will not be as much leniency going forward. If we do this again, you know, I'm going to start dealing with it through the contempt powers, because I'm just, you know, I can only do it so many times.
I recognize that, Your Honor. I appreciate the adjournment.
All right. So I think we're all set on that one.
Your Honor, if he does show up later today, I'll be available to come back onto Zoom.
Okay.
All right. Thank you.
Okay, Mr. Glazier, do you need a breakout session with Mr. Nimer?
Yes, I do, Your Honor.
All right, as soon as he gets his audio connected, I will set that up. All right, Mr. Nimer, are you there?
Yes, Your Honor, I'm here. I'm trying to turn my video camera on here.
Okay, I'm going to put you in a breakout session with Mr. Glazier so you can speak to him private.
Okay, thank you, sir.
Okay, Mr. Daly, is Mr. Smitty here? Smitty?
I haven't seen him, Judge.
Okay. Oh, he waved. I apologize.
Yeah.
Oh, okay, let's call.
Thank you. Bye.
All right, we are on the record now in file 24-21872-FH and 24-21792-FH. People versus Bailey, Assad, Neimer. We are here today for pretrial conferences, I believe, in both of those cases, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. McClure.
B.B. McClure, may have the people.
You are muted, Mr. Glazier.
John Glazier on behalf of Mr. Diamond.
Okay, and I apologize. The 218 case is set for arraignment today. So Mr. Glazier, does Mr. Neimer wish to have the information read?
No, Your Honor, we'd waive that. Ask the court to enter plea of not guilty, set that matter for a pretrial. If we could get a pretrial at least about 3 weeks ago, my client's not in jail, he's bonded out. And I want to give him an opportunity to come in and talk to him about all these files.
Okay, Ms. McClure, is there anything we need to address from the people's side?
Nothing on behalf of the people.
Okay. So I'll enter a not guilty plea for Mr. Neimer on the 21872 file, and we'll set a pretrial in both files for September 4th at 8:15 a.m.
It should be 3 files, right?
Sorry, is there a third? I've only got 2. Is there a third one?
Your Honor, there may be, but we had a pretrial where he didn't show up because we had different dates, so I want to make sure all the files are together. We sent a letter and he appeared here, but I think we were getting different trial date or different dates on different files, so we want to make sure they're all together.
So the 24-21873 FH, I think was another one up for arraignment today. Maybe, unless that's the one you said.
I think I have 3 felony files.
Yeah, so there's 21872, but also 21873 was another arraignment file, and that we want to make sure gets put on the same pretrial date.
Okay. So 24-21873.
Correct. I don't know how that one slipped by, but.
And that was an arraignment file as well, you said?
It was, yep.
Okay, and Mr. Glazier, are you gonna waive reading of that information, the 21783 file as well?
Yes, Your Honor.
Okay, so we'll enter a not guilty plea in the 21783 file also, and we'll set a pretrial in all three files for that September 4th date at 8:15.
Mr. Dimer, you set up an appointment today to come in and see me before that, okay?
Sounds good. I'll give him a call here shortly.
All right.
Okay, so Mr. Nymer, you're all set for today. You can go ahead and log out.
Thank you, Your Honor.
Thank you, Ron. That's all I have with you this morning.
All right. Mr. Noe, Mr. Hartung, you ready to proceed with Mr. Bosco?
I know, just on lockup, the deputy was taking, use the restrooms, they're back in the restroom, we're ready, but I don't know if they're back yet. He's back. They're back, all right, we're ready then.
All right.
Pretty good, thank you, appreciate that. Do. I know you do. You won't. I get it. I'm playing.
Okay, this is file 19-19463-FH, 19-19465-FC, 19-19466-FH, and 19-19467-FC. People versus Juan Antonio Vasquez. We are here today for a pretrial conference in all of those cases. We are proceeding today in person. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Hartung.
Thank you, Your Honor. Doug Hartung, attorney for the people today.
Good morning, Your Honor. Charles Noe, appearing on behalf of the defendant, Mr. Vasquez.
And sir, you're Juan Antonio Vasquez, correct?
Yes, Your Honor.
All right, Mr. Noe, how are we proceeding today?
My client will be entering a plea today. We are entering a plea today. I'll leave it to Mr. Hartung to place that agreement on the record, please.
Now, there are several files here. He's going to plead guilty to the charge of unlawful imprisonment, count 3, on the file that ends in 465 FC. The file that ends in 464 FH, he'll be pleading to count 1, which is the police officer assaulted and resisting charge. On file that ends in 467, he'll plead guilty to the added count 12. I don't know if the court received that or not. It's the charge of unlawful imprisonment on that Brandon Anger gentleman we talked about before in court today. I believe that covers the pleas, doesn't it, Mr. Noe?
It does, the sentencing in their entirety, the files that end in 463 and 466, including the habituals, will be dismissed at the time of sentencing, and all habituals will be dismissed on all the files at the time of sentencing.
And these would run concurrent.
Yes, I also agreed. There were several files that were sent to Judge Anzalone, but since this court had the lowest file number, these files have been transferred down, have been accepted by this court.
Okay, Mr. Vasquez, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Juan Antonio Vasquez, correct?
Yes, Your Honor.
Mr. Vasquez, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today in file 19-19464 FH to assaulting, resisting, obstructing a police officer?
Yes, Your Honor.
You understand that the maximum possible penalty for that offense is up to 2 years in prison and or a $2,000 fine.
Yes, Your Honor.
Is it your intention in file 19-19465-FH to plead guilty to unlawful imprisonment?
Yes, Your Honor.
And you understand the maximum possible penalty for that offense up to 15 years in prison and or a $20,000 fine?
Yes, Your Honor.
And in file 19-19467-FC, is it also your intention to plead to count 12 in that file, unlawful imprisonment?
Yes, Your Honor.
And you understand again the maximum possible penalty for that offense up to 15 years in prison and or a $20,000 fine?
Yes, Your Honor.
Are you satisfied with Mr. Noe and the advice that he's given you?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as it's been discussed on the record here today. Is that correct, Mr.?
That is correct, Your Honor.
Mr. No?
Yes, Your Honor.
Is that also your understanding, Mr. Vasquez?
Yes, sir.
If a guilty plea is accepted, there'll be no trial. It means you're giving up the rights that you would have. You would have a trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Vasquez, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
And do you understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead in file 19-19464-FH that on or about February 10, 2019, in the city of Adrian, county of Lenawee, that you did commit the offense of assaulting, resisting, obstructing a police officer?
Guilty, Your Honor.
And in file 19-19465-FC, how do you wish to plead to the charge that on or about January 26, 2019, in the city of Adrian, county of Lenawee, that you did commit the offense of unlawful imprisonment?
Guilty.
And in file 19-19467-FC, how do you wish to plead to the charge that on or about February 3, 2019, in Raisin Township, Lenawee County, Michigan, that you did commit the offense of unlawful imprisonment?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No, Your Honor.
You understand that if I accept your pleas, you'll be giving up any and all claims that your pleas were given as a result of threats or promises that closed to court on the record this morning, or that it was not your own choice to enter those pleas?
I understand, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Vasquez to plead guilty today?
No, Your Honor.
No, Your Honor.
Mr. Vasquez, other than as we discussed it on the record here this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
All right. Mr. Nui, do you want to cover the factual basis?
That'd be my pleasure. Just tell me which file to start with.
Let's go with the 19-19464 file.
Very well. May I proceed, Your Honor? Go ahead. Thank you. Mr. Vasquez, were you in the city of Adrian, county of Lenawee, state of Michigan on or about February 10th of 2019?
Yes.
And during that time, did you encounter a Officer Putnam?
Yes.
And would you agree he's a police officer of the city of Adrian Police Department?
Yes.
Was he identified as a police officer through uniform, with a badge on and everything like that?
Yes.
You see, you knew he was a police officer. Did he give you a lawful command or order to do something?
Yes.
And did you resist or obstruct that particular command? Did he ask you to do something you didn't do?
Yeah.
What did he tell you to do that you ultimately did not do?
Breeze is stop or police.
And did you do that?
No.
Okay. And did you do the exact opposite?
Yes.
Okay. Did you try to run from Officer Putnam?
Yes.
And was he able to apprehend you, or did you get away from him?
I got away from him.
Okay. You would agree that you knew, or at least had knowledge that he was performing his duties?
Yes.
And you agree when you did that, you did resist, obstruct, or oppose Officer Putnam?
Yes.
I believe that's a sufficient factual basis.
Right. Mr. Hartman, people satisfied on that file?
Yes, Your Honor.
Okay.
Which one next, Your Honor?
Let's go with the 19-19465-FC file.
Mr. Vasquez, would you agree that on or about January 26th of 2019, you were in the city of Adrian, county of Lenawee, state of Michigan?
Yes.
During that time, did you encounter a Brandon Richard Ebright?
Yes.
You went to his residence, is that correct?
Yes.
Okay. While you were there, you were involved in a group of people that were unlawfully taking some things from him, correct?
Yes.
Okay. While that was going on, did you restrain Mr. Ebright from leaving?
Yes.
Did you use a weapon or some sort of dangerous instrument to prevent him from leaving?
Yes.
What did you use?
A handgun.
Okay. And did Mr. Ebright, to the best of your knowledge, did he know that you had a handgun?
Yes.
Okay. And were you using that handgun to knowingly restrain him from leaving where he was?
Yes.
Your Honor, I believe that is a factual basis to cover count 3, the unlawful imprisonment.
We're satisfied, Your Honor. Thank you.
Okay. And so we can go to the 19-19467 file.
Mr. Vasquez, on or about February 3rd of 2019, were you in the township of Raisin, county of Lenawee, state of Michigan?
Yes.
While you were there, did you encounter a individual by the name of Brandon Inger?
Yes.
And were you at his residence?
Yes.
Okay. Were you there with a group trying to take some things from him unlawfully?
Yes.
While you were there, did you knowingly restrain him from leaving where he was?
Yes.
Was that done by with the use of a weapon or other sort of dangerous instrument?
Yes.
What was that weapon or dangerous instrument?
A handgun.
Did, to the best of your knowledge, did Mr. Inger know that you had that handgun?
Yeah.
To the best of your knowledge, did Mr. Inger see you with that handgun?
Yes.
And to the best of your knowledge, did Mr. Inger know that he could not leave that where he was because you were using that handgun?
Yes.
So I believe that's, I think, sufficient factual basis.
We are satisfied.
Okay, has the court complied with MCR 6.302 B, C, and D, Mr. Hartman?
Yes, Your Honor.
Mr. Mills?
Yes, sir.
All right, I will accept those pleas then. They've been given understandably, voluntarily, and accurately. Mr. Vasquez has had full knowledge of his rights. He's had competent counsel. Court has not made any agreement regarding the possibility of plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as we've discussed it on the record this morning. I will refer the matter to the probation department for a pre-sentence investigation.
Your Honor, sentencing date, I discussed with Mr. Hartung. I believe Mr. One of the court defendants in this matter was just early this morning set for sentencing on October 3rd. Hoping we can secure that same date as well.
Just filled up October 3rd.
Okay, sure.
I can do the 4th, the day after.
On the 3rd, was been. Charges are not available on the 4th.
But you would be available on the 3rd?
I would. And Judge, I can just, I don't want to make any promises I can't keep, but my evidentiary hearing I have set with you, with Mr. Raines on October 3rd is not quite resolved, but very close to doing so.
All right, so let's go with October 3rd then, and we'll see if we can move one of the other ones that's set for October 3rd to a different day.
Thank you, I appreciate that very much.
Thank you, Your Honor.
That's at 8:30?
At 8:15.
8:15.
Mr. Vasquez, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Thank you, Your Honor.
Okay, thank you. Never picked down Mr. Vasquez secured. All right, Mr. Malero, I do have Mr. Lindsay on Zoom. Are you ready to proceed with it? All right, we are on the record in file 24-21749-FH, People versus Jason Lindsay. We are here today for a pretrial conference in this matter. We are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure.
Phoebe McClure, on behalf of the people.
Salvatore Malero on behalf of Jason Lindsay.
All right, and we have Mr. Lindsay here by video conference. Sir, you are Jason Lindsay?
Yes, sir. Yes.
All right, Mr. Malero, where do we stand with Mr. Lindsay's case today?
Your Honor, we're close to having this resolved. However, I spoke to Mr. Coast. Apparently, is there a show cause in the file? Take your hat off, Mr. Lindsay. You're in court.
Sorry about that.
Yeah, okay, so we do have a show cause set for today as well, for an alleged failure to submit to a breath test. So let me just ask a couple questions here. Mr. Lindsay, did you get a copy of that show cause?
I did not.
All right, so we'll make sure we get you a copy of that. The show cause alleges that you failed to submit to a morning breath test from July 15, 2024 to July 25th, 2024. The maximum possible penalty for contempt of court would be up to 93 days in jail or $7,500 in fines. Mr. Blair, do you know how he wants to proceed on the show cause?
So Judge, we would stay on mute on that. I did talk to Mr. Coast and then asked to set that out. I was gonna ask on the instant action for a brief adjournment. I think we're close to resolving it, but I need to talk to the prosecutor.
Ms. McClure, are there any issues that you need to address?
Nothing on behalf of the people.
I will set this then for September 11th at 8:15 a.m. We'll set the show cause out to that date as well. Mr. Malera, would you be willing to do that stipulation in work?
I would. Your Honor, is there a bond on the show cause? Or do we need to set one?
No, there's no, he's not being arrested on, he just has to appear and respond to it.
Okay,
So we're all set there.
I agree. Thank you, Your Honor.
Okay.
And I forget, but I'll do the step order.
Thank you.
Thanks.
Mr. Daly, are you ready to proceed yet?
Yes, sir.
Okay. All right, so this is file 23-21462-FC, People versus Michael Sepulveda.
Thank you, Your Honor. Benita Hoffman, Assistant Attorney General, on behalf of the people, P48738.
James Danforth.
All right, and Mr. Daly, how are we proceeding today?
Your Honor, we have a plea bargain in place. We're ready to plead guilty pursuant to plea bargain.
Okay, and what are the terms of that agreement?
The plea bargain is that this defendant pleads guilty to second degree murder. The sentence would be a 10-year sentence. He's required to testify truthfully against his brother in regards to that. He's also required to meet with the detectives in this case and the Attorney General prior to trial and to cooperate with them. Beyond that, there's really not much other to add than the 10-year sentence. If the court would exceed the 10-year sentence, he has the ability to withdraw his plea and at that time proceed to trial if we choose to.
Your Honor, that's a correct statement of the agreement, that it's a 10 to 30 year sentence, meaning 10 years is the minimum and 30 years as the maximum. So the court is aware the sentencing guidelines as we calculated are 270 months to 450 months or life. Therefore, will be 22.5 to 37 years if the defendant were found guilty of this offense without any plea bargain. In addition to pleading guilty to the count 3 murder in the second degree, we would be dismissing the balance of the charges, which would be counts 1 and 2 and counts 4 through 7, as well as the habitual offender supplement. Obviously, this is all contingent upon Mr. Sepulveda giving truthful testimony, and it is also very much contingent on his continued cooperation by meeting with me and or anyone else from the Attorney General's office and the detectives in this matter.
So has the amended information been filed with the clerk's office yet?
Yes, Your Honor, it has been. That's your copy, Steve.
So my only concern is that we've changed some of the counts. So count 3 on the original information was assault with intent to maim. And
Yes,
now
Your
count
Honor.
3 is second-degree murder. And we can't do that in our computer system. So when we amend an information, if you have a new count, it has to be added as the next count in the list. We can't change count 3 from one thing to another thing.
Okay,
So we're gonna need a new amended information, making the second-degree murder charge, going back to the original one, and then just adding the second-degree murder charge as
count 7.
count 7, yeah.
Based upon that, Your Honor, I would move to amend the plea agreement and say that counts 1 through 6 will be dismissed, and that he will be pleading to count 7. And then I can file an amended information later on today or tomorrow. So the court has that, but the court does have all of the correct information before it. I would like to approach the court with the plea agreement, if I may.
Okay, first, Mr. Daly, I presume you would not have any objection to that next amendment of the information. So you can go ahead then, Ms. Hoffman. And
Thank you, Your Honor.
copy that. Okay, so I have received the written plea agreement, appears to be signed by Ms. Hoffman, Mr. Daly, and Mr. Sepulveda, and I'm placing that in the file. Okay, so Mr. Sepulveda, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Michael Sepulveda.
Yes, Your Honor.
Mr. Sepulveda, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to, it's going to be count 7 on the amended information, second-degree murder?
Yes, Your Honor.
You can put your hand out if you want. Do you understand that the maximum possible penalty all right, so this says life without parole, but the maximum penalty or the penalty for second-degree murder is life in prison or any term of years? You understand that?
Yes, Your Honor.
That for you. Okay. You've reached an agreement about your sentence with the prosecution, but I'm required to tell you what the maximum possible penalty would be. That's all I'm doing. Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court, other than as we've discussed it on the record here this morning. Is that accurate, Ms. Hoffman?
Yes, Your Honor.
And Mr. Chair. Is that also your understanding, Mr. Sepul?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty. You do not have to prove anything. You have the right to be present at trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Sepulveda, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
You also understand that any appeal from the conviction and sentence pursuant to this plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
And do you understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about January 1, 1997 to November 19, 1997 in Blissfield Township, Lenawee County, Michigan, that you did commit the offense of second-degree murder?
I plead guilty, Your Honor.
Has anyone made any threats or promises to induce you to plead guilty to that charge?
Just the maximum for my minimum is 10 years, and then my max is 30 years, 10 to 30 prison sentence.
Other than that plea bargain and agreement that we've addressed on the record here today, has anyone made any other threats or promises to induce you to?
No, Your Honor.
Do you understand that if I accept your plea, you'll be giving up any and all things that the plea was given as a result of, threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Sepulveda to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Sepulveda, other than as we've talked about it on the record this morning, has Mr. Daly promised you any particular sentence or estimated what your sentence would be?
Just what we talked about, Your Honor.
Okay, nothing other than that? Is it your own choice to plead guilty today?
Yes, Your Honor.
All right. Mr. Daly, do you want to cover the factual basis?
Yes, Your Honor.
Go ahead.
Between the 1st of January 1997 and November 19th of 1997, were you involved in the murder of an individual known as John Doe?
Yes.
And you were involved in that murder with your brother?
Yes.
And what is your brother's name?
Ricardo Sepulveda Jr.
Okay. And he was murdered because you took money from him that he was supposed to take back to a drug organization. Is that correct?
My brother was supposed to turn in the money to somebody, and then instead of turning the money in, he murdered the person.
Okay. And at the time that happened, your brother was there and you were both there?
Yes.
Okay. And you did in fact murder the individual known as John Doe?
Yes, yeah.
And then did you cut off his hands and feet and head?
Yes.
And did you place the corpse in a field and bury it in Blissfield?
Yeah, we didn't bury it, but we placed it in the field with a little dugout.
Yeah, okay. I don't believe I have any other questions, Your Honor.
Ms. Hawkins?
Just a point of clarification, was it the hands and head that were cut off, or the head, the hands, and the feet?
Just the hands and the head.
Thank you. And was this person killed in Lenawee County, Michigan?
Yes.
And did you actively participate in the killing of this individual?
Yes.
And did Ricardo actively participate in the killing of this individual?
Yes.
And is it true that this individual was stabbed 3 times in the abdomen?
Yes.
Is it also true that this individual had previously been hit in the head with a rubber mallet?
Yes.
And that you carried him in a vehicle to Lenawee County where he was killed, is that right?
Yes.
Okay, and did you douse him with some sort of a chemical to remove fingerprints?
Yes.
What chemical was that, if you recall?
I can't recall. I think it was Drano or bleach, one of the two.
Okay, and the clothing from the body of the decedent, John Doe, where did it go?
In a trash can behind a bar called Bunkers on Upton Avenue.
And what county, what state is that in?
Toledo, Ohio.
Okay, and then with respect to his head and hands, what happened to those?
They were thrown in the 10-mile creek and off the Stickney Avenue and Stickney Avenue Bridge, under the bridge by the Perstorp Chemical Factory.
And were you involved in throwing those items into those parts of his body, into the river?
Yes.
And was Ricardo Sepulveda there and involved in that process?
Yes.
When you transported this individual from Ohio to Michigan, was he still alive?
Yes.
Thank you. I have no further questions.
All right, has the court complied with NCR 6.302 B, C, and D, Ms. Hall?
Yes, Your Honor.
Mr. Bailey?
Yes, Your Honor.
All right, I will accept a plea then. It's been given understandably, voluntarily, and accurately. Mr. Sepulveda has had full knowledge of his rights to have competent counsel. Court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than as we've talked about it on the record here today. I will refer the matter to the probation department for a pre-sentence investigation. And we will set sentencing for October 10th at 8:15 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor. Okay. Anything else we need to address with this case today?
I have nothing, Your Honor.
I would ask that if this hasn't happened already, that he does not have any communication with Ricardo Sepulveda about the matter, and that he not talk with anybody over at the jail other than authorized personnel from the court regarding the incident, or the Attorney General's office and the detectives.
Okay, Mr. Bailey, any issue with that?
No, Your Honor.
Okay, so we'll modify Mr. Sepulveda's bond to include those conditions. Mr. Sepulveda, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background. Yes, Your Honor.
Your Honor, I forgot, regarding bond, I don't think that the defendant should be released on bond, even if he's able to post it if there is a cash bond listed. He's now convicted of the offense. So under MCL 770.1, I think it is, the court is supposed to remand him without bond because it's a violent offense. It's one of the listed violent offenses.
We've got no problems with that, Your Honor. He has several years to complete before he has 10 years in anyways. Neither the defendant or myself want any confusion in regards to this matter or any contact between him or anybody else. So we believe all of the Attorney General's requests are reasonable, and we have no objection to any of those.
Okay, and that is accurate and appropriate that the court should revoke bond, remand Mr. Sepulveda to custody at this point based on his plea to the violent offense. So I will do that.
Thank you, Your Honor.
All right, I think we're all set. Thank you,
Judge. See you later.
Okay, and so we can call the photos. This is file, oh, I'm sorry. Mr. Daly? Mr. Daly, I need you to stay for maybe 5 more minutes. We have Nathan Edwards that was arrested last night.
Oh, okay.
On his bond violations.
Okay.
So we'll call the jail for him right now. All right, so this is file 23-21463-FC, People versus Ricardo Sepulveda. We are here today for a pretrial. In this case, first, can I ask the attorneys to place their appearance on the record, beginning with Ms. Hoffman?
Thank you, Your Honor. Benita Hoffman, P48738, on behalf of the people as the Assistant Attorney General.
Good morning, Your Honor. William Amadeo, P76194, on behalf of Ricardo Sepulveda. I am here for him. I waive his presence today, and I will speak to him after when I go see him in the Washington County Jail.
All right, and so where do we stand with this case today?
I believe we just need a trial date, Your Honor, and I know the AG and I spoke outside. My concern right now for January is I have the old housing case, which is before you, obviously. I have another capital in Wayne on the 27th. We have the objection to the middle of February. I'm not asking for bond. I just want to make sure with the new, what just happened today, it changes my strategy for trial, obviously, Judge. And I would also like to order a transcript from today. If you can point me in the right direction, I'll pay for that. And I'll start reviewing everything with my client and start cover for trial.
I had planned on a severance motion, that's moot now. I don't know if there's any other motions that Mr. Simpleview want me to file, but at this point, I think it's just trial prep.
If I could, Your Honor, I'm fine with February trial date in this matter. I would state for the record that after speaking with Mr. Amadeo, he's indicated that they are willing to stipulate to the admissibility of the autopsy report. Therefore, I would like to put that on the record, and I will prepare a proper stipulation to present it to the court. We may still have a motion in limine to file. Other than that, we're prepared to go to trial in February.
To be clear, Judge, on the autopsy, I don't think that's going to be an issue. And I think I did say to AAG Hoffman, if there's other things she would like me to stipulate to, that's going to save us time, I certainly will, but it's not going to be hurtful to the case. I have to study everything she'll want stipulations on. If there are no issues, I'll certainly sign and present it. I do want to talk to my client before any final decisions, but I do want to make this process as short as possible and just prepare diligently.
Okay. And so how many days will you need for trial?
We believe we can complete it in 5, Your Honor.
It may be less, but I think 5 safe, Judge.
Okay. So Ms. Clark, could we have a 5-day jury trial date in the middle of February?
Tuesday, February 11th at 9 a.m. Wednesday, February 12th at 10:30. February 13th at 9 a.m. February 14th at 9 a.m. and Tuesday, February 18th at 9 a.m.
That'll work for defense, Judge. Thank you. It's okay with the people.
Thank you, Your Honor. That's fine.
Okay, and then how about a final pretrial then on January 29th at 8:15?
January 29th.
29th.
I don't want to speak for Your Honor, but I don't feel any issue appearing on Zoom for that one, correct, Judge?
That's fine.
Your Honor, if I am still in my waiting trial, I'll make sure somebody's covering it and be in communication with the AG well ahead of anything that's going to happen prior to trial.
We could go to the February 5th would be the next Wednesday if that.
Yeah, I could be February 5th. That's acceptable, Your Honor.
Thank you,
It's
Your
fine,
Honor.
that works.
That's fine.
So we'll do the February 5th date then. And the court will issue a scheduled order and mail it out to you.
Thank you.
Thank you, Judge.
Your Honor, do you require that we prepare the jury instructions and submit to the court, or does the court do that on its own?
So what we ask you to do is get together with Mr. Amadeo and see what you agree upon. We have a kind of a standard set, which there'll be contact information for Sierra Graves, who is our judicial attorney in the scheduling order. And so if you want to know what our kind of general standard ones are, she can give you those. Any of the case specific ones, we ask you to meet with Mr. Amadeo. If you agree on them, you can submit a stipulated copy. If you have disagreements, you can submit your own. Those motion, hopefully at the final pretrial.
Okay. Thank you, Your Honor. I appreciate your courtesy.
Thanks, sir. Thank you. Okay, and is Mr. Sinclair here? And Mr. Sinclair and Mr. Dillard? You're Mr. Dillard. Okay, so we're just, Ms. Underwood is the attorney for both of you in both your cases. She is in Judge Angelo's court doing cases right now. As soon as she's back here, I will call your cases, but we need to have her before I can do it. And Mr. Kier. Okay, so same thing with you, Ms. Underwood, your attorney, as soon as she's back in my court, I'll, I can't hear what you said. Yeah. All right, Mr. Kira, I'll call your case next. All right, we are on the record now in file 24-21781-FH, 24-21782-FH, 24-21783-FH, 24-21784-FH, and 24-21785-FH. People versus Nathan Wayne Edwards. We are here today for arraignment on a bench warrant or on bench warrants in each of those files. Sir, you are Nathan Wayne Edwards?
Yes, Your Honor.
All right, Mr. Edwards, have they given you copies of your warrants yet?
Not yet, no, sir.
All right, can you stick your head out and tell them that you need to have copies of your warrants given to you?
Yes, sir. Yes, Your Honor. I need copies of my warrants. Sir. What? I need copies of my warrants in front of me and stuff.
Copies of your warrants?
Yeah.
Edwards?
Yes.
Gilbert, you got Edwards? He's passing the ball going.
All right, so we'll wait for jail staff to get you those warrants, Mr. Edwards. I will let you know that the warrant alleges that you failed to appear for a show cause hearing on June 26, 2024 at 8:15 a.m. There's a warrant in each file. They all say the same thing. The show cause relates to an allegation that you tested positive for methamphetamine on June 4, 2024. The maximum possible penalty for a contempt of court is up to 93 days in jail or up to $7,500 in fines. You do have the ability to be represented by an attorney at this hearing and at any other hearings we have regarding this matter. If you can't afford an attorney, you can tell me that. I'll appoint one for you at public expense. Mr. Daly represents you on the underlying cases, and he's here today. Do you want him to represent you on this warrant as well?
Yes, Your Honor.
All right, Mr. Daly, do you want to place your appearance on the record?
James Daly.
All right, and do you want time to speak to Mr. Edwards?
No. We would waive the reading of the warrants. Mr. Edwards knows what's happened. I know what's happened. It'd be my suggestion to Mr. Edwards that he pleads guilty, get these warrants out of the way. He's not going to be able to bond back out. He's going to sit in jail until this matter is resolved, or there is a trial. And it's just better for him to get these matters behind him as quick as he can. I've communicated that to him in the past before he took off. Nothing's changed.
Okay. So, Mr. Edwards, is that how you want to proceed today?
Yes, Your Honor.
All right. Could you raise your right hand, please? You swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are Nathan Wayne Edwards?
Yes, Your Honor.
Mr. Edwards, do you understand you have a right to contest the contempt of court charge and to have a trial?
Yes, Your Honor.
Do you understand that throughout that trial you'll be presumed innocent until your guilt is proven beyond a reasonable doubt?
Yes, Your Honor.
You have the right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions, and you also have the right to have me order any witnesses you have for your defense to appear at your trial. Do you understand that?
Yes, Your Honor.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes, Your Honor.
On the other hand, you understand that you have a right to testify at your trial if you wanted to testify.
Yes.
How do you plead to the charge that you failed to appear in court for a show cause hearing on June 26, 2024?
Guilty, Your Honor.
And how do you plead to the charge that you tested positive for methamphetamine on June 4th, 2024?
Guilty.
You understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained.
Yes, Your Honor.
Has anything been promised to you in order to get you to plead guilty?
No, Your Honor.
Has anybody threatened you in any way in order to get you to plead guilty?
No, Your Honor.
If I accept your plea, you'll be giving up any and all claims that your pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the pleas. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your
Honor. So you've been on bond in these cases since the cases started, is that right?
Yes, Your Honor.
Yeah,
since they started, I was in jail for several weeks before the bond to go.
Okay, so your bond conditions require that you not use any illegal controlled substances, is that correct?
Yes, Your Honor.
And you tested positive for methamphetamine in a test that was collected on June 4th, 2024, is that right?
Yes, Your Honor.
And then as a result of that, we sent out a show cause to have you appear in court and respond to that alleged violation. And you did not appear at that show cause hearing on June 26, 2024. Is that right?
Yes, Your Honor.
All right, I'll accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Edwards has had full knowledge of his rights. He's had competent counsel. Mr. Daly, is there anything you want to say on Mr. Edwards' behalf before the court passes sentence?
Only, Your Honor, Mr. Edwards, at some time is going to have to get his life together. He's going to have to deal with these things. We are not going to get to trial before he would complete a sentencing on this violation. Beyond that, we have nothing else to add.
All right, Mr. Edwards, is there anything you want to say on your own behalf before the court passes sentence?
I just apologize for the court for not showing up. I made a mistake. I should have came in and faced the consequences of what of driving dirty, and I apologize for that.
All right, it's going to be a sense of the court that, well, I think for two reasons. First, we had the positive drug test that was obviously compounded by the failure to appear and respond to the show cause. And so there's really two issues there. I think based on that the 93-day jail sentence is appropriate. So it will be a sense of the court that you serve 93 days in the Lenawee County Jail with credit for 1 day served. That's in each of the files, yeah. All right, and so bond on the bench warrants was $50,000 in each file. That I'm going to modify the bond and the underlying charges so that they're the same as on the bench warrant in each file.
Thank you.
Thank you. Do you want to set a pretrial and so we can get another trial date scheduled? Mr. Daly, how about September 4th? I'm sorry, no, let's go with September 20, or August 28th would be 2 weeks from today. We'll do that.
I think I'm at trial that day and Jackson here, I'm set for trial that day. I don't think it's going to go, but I'm still set for trial that day.
Okay, how about September 4th?
The what?
September 4th.
Oh, Judge.
Okay, so we'll set it for a pretrial on September 4th at 8:50. Okay, Mr. Edwards, you can let the officer with you know that you are done with court for today.
Yes, sir. Thank you, Your Honor. Oh.
Sir, Kyrie, you want to come forward? Here. This is file 21-20551-FH. People versus Timothy Allen Kyer. We are here today for summons for probation violation. Sir, you are Timothy Allen Kyer.
Here.
Okay. And I'm sorry, there are 3 files. So the one that I read also 20-20077-FH and 21-20552-FH. Right, Mr. Kier, you received copies of those requested summons for probation violation.
I think there's 4 cases.
All right, I got 3 papers. I haven't been convicted on a domestic violence.
Okay, just hang on a second.
Yeah,
I only have
There's
3
3.
files. So, okay, so Mr. Kier, did you receive copies of the requested summons for probation violation?
Yeah.
Okay. Those documents allege that you violated the terms of your probation by failing to report as instructed on July 23, 2024, and by failing to pay costs of $198 in the 21-20551 file. And $334 in the 21-20552 file. The other requested summons is not in the file. Ms. Holly, do you have the amount in the 20077 file?
Check.
All right, we'll get you that amount in a moment. In the 21-20551-FH file, Mr. Carey, you had pled guilty to assault with a dangerous weapon. The maximum possible penalty for that offense is up to 4 years in prison and or a $2,000 fine. In the 21-20552 file, you had pled guilty to 2 counts of resisting and obstructing a police officer. Maximum possible penalty for those offenses is up to 4 years in prison. You'd also pled guilty in that file to unlawful use of a motor vehicle. And maximum possible penalty for that is up to 2 years. And in the 20-20077 file, you had pled guilty to attempted larceny from a building. The maximum possible penalty for that offense is up to 2.5 years in prison and or a $5,000 fine. You have the right to be represented by an attorney here today and at any other proceedings that we have regarding these allegations. If you can't afford an attorney, you can tell me that now and I'll appoint one for you from the public defender's office. Do you understand that?
Yeah, sure.
Do you want to be represented by an attorney?
No. Yeah.
Okay. Do you have the ability to pay for your own attorney?
No.
Okay. So I'll appoint the public defender's office to represent you. Ms. Underwood is here in the courtroom right now. So what I'll do, she's got a couple other cases I'm going to have to call. So if you go back and sit down, I'll have her speak to you in just a minute after she's taken care of a couple other cases. Okay.
All right.
077 case, he owes $1,358.
All right, so $1,358 is the amount of the cost in that other file. Okay, so if you have a seat for just a minute, I'll have Ms. Underwood speak to you as soon as she is available. All right, Ms. Underwood, are you ready to proceed with Mr. Dillard?
Yes, Your Honor, thank you.
All right. Mr. Malero, do you have another case?
Judge, I'm gonna cover Mr. William Raymond and Stacy Marquis from that Murphy.
Okay. All right, Mr. Dillard, you want to come forward? You can sit at the table here closest to the television. This is file 24-21905-FH, People versus Zachary Ryan Dillard. We are here today for a arraignment. In this case, we are proceeding today by video, in person and by video conference. First, let me ask the attorneys place their appearance on the record, beginning with Mr. Bayoneto.
Good morning, Your Honor. Alex Bayoneto for the people.
And Ms. Underwood.
Ron Underwood for Mr. Dillard. Thank you, Your Honor.
All right, and does Mr. Dillard wish to have the information read?
Mr. Dillard would waive the reading of the information, acknowledge its receipt and the receipt of the witness list, Your Honor. Your Honor, we're close to a resolution on this matter. We would ask that it be set over for one pretrial. The reason we're here in addition to the arraignment this morning, and we would ask the court to enter a not guilty plea on Mr. Dillard's behalf. The reason we're here this morning, Your Honor, is we just wanted to make sure Mr. Dillard has a trip that has been planned for a long time, Your Honor. Mr. Dillard, that's to
Yes, I had planned a trip like a couple months ago to take my girlfriend to Arizona for 5 days. It's September 6th through the 10th.
I don't believe Mr. Sneed had any objection to the bond being modified to allow Mr. Dillard to make those travel plans. I don't believe Mr. Dillard has made his court appearances on this, Your Honor, and the plea bargain that's been offered is one that I believe we're going to take advantage of.
All right, so we'll enter a not guilty plea for Mr. Dillard. Mr. Bayonetto, do you have any response on the request for a modification of the bond conditions to allow Mr. Dillard to travel to Arizona? Was it September 6th?
Yeah, September 6th.
September 6th through 10th.
Yeah.
Your Honor, I have no position. I'll defer to your discretion.
All right, so I will modify the bond so that Mr. Dillard can travel to the state of Arizona from September 6th to September 10th.
Your Honor, I am on colors, so like when I call my colors, do I have to like just find somewhere down here to drop and then just have them send it up here, or?
Yeah, why don't you get in contact with Mr. Coast? He may be able to help you if you give him the location, search out a place where if you get called, you drop on down. Right. All right, anything else today, Ms.
Not today, Your Honor. Thank you.
Okay, thank you. Oh, so we need a pretrial date. I apologize. Let's do a pretrial on September 18th at 8:15.
September 18th.
Sounds good.
Will you be sending notice, Your Honor?
Yes, yeah.
Okay, thank you.
All right, are you ready on Mr. Sinclair?
On who?
Mr. Sinclair?
I could just have a second, Your Honor.
Okay.
Thank you, Your Honor.
Okay, so this is file. File 24-51771-PP, Sarah Ann Sinclair versus Matthew Richard Sinclair, here today on alleged personal protection order violation. We are proceeding today by video conference and in person. First, let me ask Ms. Unwin to place your appearance on the record.
Ron over to Mr. Sinclair this morning, Your Honor. Thank you.
All right, where do we stand with Mr. Sinclair's case?
I believe the court cleared up the confusion that there were two separate, that we had the last time we were in court, Your Honor, that there were two separate allegations of PPO violations on the same day, Your Honor. However, they are connected with a felony, a new felony that Mr. Sinclair has picked up, that Mr. Malero has scheduled for a probable cause hearing on the 22nd, Your Honor. So I would ask that this be adjourned until after that.
Okay, on the 22nd, so let's go with. Was September 4th at 8:15.
Thank you, Your Honor.
All right, anything else on this case today?
Thank you.
All right, thank you.
Thank you, Your Honor.
And then, Ms. Underwood, do you want to speak to Mr. Kier?
I will speak to Mr. Kier, Your Honor.
Okay, Mr. Malero, I think we have Ms. Marquis getting her audio connected right now. Okay, this is file 23-21551-FH, People versus Stacy Lee Marquis. We are here today for a pretrial conference in this case, and we are proceeding today partially in person, partially by video conference. First, let me have the attorneys place their appearances on the record, beginning with Mr. Bayonet.
Alex Bayonet for the people.
Salvatore Malero on behalf of Matt Murphy for Stacy Marquis.
All right, and Mr. Malero, where do we stand with Ms. Marquis' case today?
And we're asking to adjourn the matter. The basis is that, according to Mr. Murphy, there is a diversion being taken place or going to be taking place. That's the reason for the adjournment.
Okay, Mr. Bayonet, anything to address from the people's side?
No, Your Honor. Ms. Marquis is making good progress with diversion, so hopefully we can have this case resolved shortly.
Go with October 2nd at 8:15, if that works.
That's good for us, Judge.
Okay, Mr. Malero, can the PD's office do the stipulation for?
Yes, Your Honor.
Okay, so Ms. Marquis, you are all set for today. You can go ahead and log out. All right. So, Mr. Malero, are you ready for Mr. Raymond now?
Yes.
Okay, so I think we have Mr. Raymond here. This is by sir, are you Mr. William Raymond?
Yes, Your Honor. Can you hear me?
Yes, so this is file 24-21807-FH, 24-21808-FH, and 24-21890-FH. People versus William Michael Raymond. We are here today for pretrial conferences. In each of these cases, they also have pending contempt. It looks like we are proceeding today partially by video conference and partially in person. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Bayonet.
Alex Bayonet for the people.
Salvatore Malero covering for Matt Murphy on behalf of William Raymond.
Okay, and Mr. Malero, where do we stand with Mr. Raymond's cases today?
Your Honor, according to Mr. Murphy, there may be new charges coming And he's also going to be, looks like screened for drug courts. We asked their attorney later out.
Mr. Netto, anything that we need to address from the people's side today?
No, Your Honor. I know new charges were authorized. I don't know if they've made their way to the court yet to be submitted, but those will be coming. So I think an adjournment probably is appropriate in this case.
Okay, so we're gonna need some time if there are new charges to work their way through. How about October 16th at 8:15?
That's fine, Judge.
And Mr. Valero, can the PD's office do the stip in order on that as well?
Yes.
All right,
Your Honor, you said October 16th?
correct. At
Okay,
8:15.
all right.
Okay, so you can go ahead and log out, Mr. Raymond.
Judge, did you say there
One
was
second.
a contempt or something?
Yes, there are. There were pending contempts that he's already, I think, pled not guilty to,
Oh, okay.
related to a failure to appear.
All right, just checking.
All right, Ms. Underwood, are you ready to proceed with Mr. Kier then?
I am.
Thank you, Judge.
Mr. Kier, you want to come back forward, please? So we're back on the record in People versus Timothy Allen Kier. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Kier, Your Honor.
And you know how Mr. Kier wishes to proceed?
Your Honor, in view of the fact this violation does contain allegations of a matter that is now down in district court for a pretrial dated September 20th, Your Honor. I'm sorry, or October or August 20th. I'm sorry, August 20th. We would ask that the court issue a not guilty plea and set this matter for after that period, Your Honor, so that we can have some idea what is going to take place on that case.
Okay, so these were just failures to appear and failure to pay costs. That's
Right,
something-
and there is also another allegation. Unless I'm,
Oh, I apologize, I missed that. You are correct. There is an allegation that probation was violated as a result of a domestic violence. That's the thing that's pending. Okay, I apologize. So August 20th, you said was the hearing?
yes,
Let's set it for August 28th then at 8:15.
thank you, Your Honor.
Okay, so
And-
August 28th at 8:15.
Your Honor, Mr. Kier, in terms of the fines, Mr. Kier owns fines on several old cases, I think. And when he comes in with cash, they won't let him allocate to specific cases.
Oh, no, it's going toward these cases. It's just going to the oldest one of these three cases first. So his payments aren't going to these.
But I'm asking for some instruction. How, is there some way he can specify what cases he wants to pay on?
Well, Ms. Holly said they're going to these three cases, but it goes to the oldest case number first. So the money he brings in is going toward these cases.
No, it's
Yeah.
not.
Yeah, it is.
The last time I brought in, they give me a thing, it went to a case that I was.
Your
Send
last
the prison-
payment went to the case ending in 077. So that's one of these cases.
Not on probation from 07.
No,
No,
the
it's-
077 case, there's a case that has a file number that ends in 0077. It's not a zero, it's not a
From what year
3077
ago?
case. from 2021. It's one of these three cases that we're here talking about today.
Then how come I still owe $334 and like I still owe the same amount on all of these charges?
I don't know. I don't have the payments in front of me today. If there's an issue with the payments, I can address that, but I don't have the information that I need today to do that.
I have to go through a lot of stuff to find it.
Okay. Thank you.
Set for 28th at
28th at 8:15.
8:15.
Correct.
Thank you, Your Honor.
Thank you, Your Honor.
All right, and sir, you're Mr. Monier?
Monier.
Monier, okay, yeah.
Excuse me. Can I ask one more quick? Do I need to go see Miss Holly? I don't
Ms.
know.
Holly, do you need Mr. Kier to see you today? Or do you-
No, just your next report date. I don't know, is that next Tuesday probably?
Is it in 2 weeks is it in 2 weeks or next week?
I think it's next week.
All right, thank you.
I didn't see you this week, so next week.
All right, thank you. Have a great day.
Yep.
Did Mr. Sinclair, you still have Mr. Shelton and Mr. Rakes?
I'm done.
Let me do these first. Yes.
Okay, great.
Yeah, sorry. Okay, so this is file 24-21902-FH versus Russell Micah Monier. First, we are here today for an arraignment in this case. We are proceeding today by video conference and in person. First, let me ask the attorneys to place their appearance on record, beginning with Mr. Bayonetto for the people.
Alex Bayonetto for the people.
Hi, good morning, Judge. Good morning to your staff. Caitlin Crapo, P86272, on behalf of Mr. Monier, who stands to my right. We are appearing in person, or sorry, my left. Mr. Monier, please state your name for the record.
Russell Michael Monier.
Thank you.
All right, and first, thank you for your patience. I didn't see you that you were sitting here in person. I tried to get to people in person first, but I didn't know who you were, so I didn't know what case to call. So.
No, Judge, for the record, I'm sitting in the hallway on a PPO matter, so
All right.
I was unavailable anyways. I just was here.
Okay, so does Ms. Crapo, does Mr. Monier wish to have the information read?
No, Judge, he would stand mute and enter a plea of not guilty and waive the formal reading of the information. I don't believe the information has changed since we waived the preliminary exam.
Okay, so I will enter a not guilty plea then, and we can set a pretrial for.
Judge.
Oh, I'm sorry.
We were tendered a plea in this matter, and it is a plea that we hope to take advantage of.
Okay.
So I don't know if we will need to set another pretrial because I have it in hand. I just wanted to clarify something on the record before we officially entered it, if that was okay with the judge.
Yeah, go ahead.
I just wanted to clear up with Mr. Bayonetto. It just says, subsection 3 of the plea agreement, it says no upfront jail, and I just wanted to just verify what that meant. I just want clarification.
Part of the plea agreement was that we would agree that the sentence would include no upfront jail. That
So
the sentence agreement box is checked, reflecting that.
Great. I just wanted to I just was trying to see if it was like a suspended sentence or if it was like a probation. That's my only, no upfront jail. I just technicality wise, I just wanted to make sure what we were looking at before we agreed.
That would likely be a suspended sentence from the judge, but I would defer to him at this point.
Okay.
So typically what we mean in this county when that term gets thrown around is that there may be a suspended sentence, but no jail sentence would have to be immediately served. So it would be a probation sentence, perhaps with a suspended jail sentence, but perhaps not.
Great. That's awesome. I just wanted to make sure. My other question was in the district when we did our waiver hearing last week, Mr. Bayonetto indicated that he would be dismissing there are misdemeanors that are attached to this, or not misdemeanors, tickets that are attached to this. They're saying the district court was split, I believe, and I just wanted to make sure, I just wanted to double check that those will be dismissed.
Yes, that they've already been prepared. I was going to file them as soon as this hearing is done.
So everything that's left in the district will be dismissed.
Correct.
Okay, great. So we're ready to enter this plea today, Judge, if Mr. Bayonetto is ready and if you are ready to accept the plea, Judge.
All right, and so just so we have a clear record of everything, then Ms. Crapo, do you want to state what you believe to be the complete plea agreement? And I'll ask Mr. Bayonetto.
Absolutely, and just for the record, I am reading this from the plea agreement that was tendered to me by Mr. Bayonetto earlier this week. It says that defendant will be pleading guilty to count 1 as charged. The Lenawee County Prosecutor's Office will be dismissing the habitual offender notice. They will, it's not on this form, but they will also be dismissing the tickets left in the district court, and that there will be no upfront jail, which we clarified to mean no upfront jail, and that discretion will be left with the judge. And Mr. Monier will be waiving, entering this plea, pleading guilty, and obviously waiving all trial rights. Thank you.
Okay, Mr. Bayonetto, is that a complete and accurate statement of the plea agreement?
It is, Your Honor, yes.
Okay, and Mr. Monier, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Russell Micah Monier?
Yes.
Mr. Monier, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, possession of analogs?
Yes.
Are you satisfied with Ms. Crapo and the advice that she's given?
Absolutely.
Do you understand that the maximum possible penalty for that offense is up to 2 years in prison and or a $2,000 fine?
Yes.
Neither the prosecutor, defendant, nor anyone acting on the defendant's behalf has discussed possible sentence with the court other than as we've discussed it on the record here today. Is that correct, Mr. Bayonetto?
Correct, Your Honor.
Ms. Crapo?
Yes, Judge.
Is that also your understanding, Mr. Monier?
Yes, yes.
All right. If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had. I'm explain those rights to you now to make sure that you understand. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you were guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You also have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Monier, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
And you also understand that any conviction, any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
You understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about May 3rd, 2024, in Ridgeway Township, Lenawee County, Michigan, that you did commit the offense of possession of analogs?
Guilty.
Has anybody made any threats or promises to you to induce you to plead guilty to that charge?
No, sir.
You understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea? Is prosecutor defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Monier to plead guilty?
No, Your Honor.
No, Judge, thank you.
Mr. Monier, other than as we've discussed it on the record here today, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, sir.
Is it your own choice to plead guilty today?
Yes.
Ms. Craig, do you want to cover the factual basis?
I have it up if you would like. Yes, I don't mind wondering.
Okay, go ahead.
Mr. Monier, on or about May 3rd, 2024, were you driving in the location of Ridge Highway and the Interstate 50, I believe it was?
Yes.
And were you in the county of Lenawee?
Yes.
And at that time, were you pulled over by police?
Yes.
Did they search your vehicle?
Yes.
Did that search result in controlled substances less than 25 grams that you did not have permission to have?
Yes.
Defense is satisfied, Judge.
Okay, Mr. Bayanetto, are the people satisfied with the factual basis?
Yes, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Mr. Bayanetto?
It has, Your Honor.
Ms. Craig?
Yes, Judge.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Monier's had full knowledge of his rights, and he's had competent counsel. Court's not made any agreement regarding the possibility of a plea or sentence in this case with prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, except as we've discussed it on the record here this morning. I will refer this matter to the probation department for a pre-sentence investigation, and we'll set sentencing for, we do September 20th at 8:15, if that date works.
One moment, Judge. Let me check my schedule. And I just do have one concern regarding the sentencing after I check. Unfortunately, I will be out of town on the 20th. I'm out of office that day, but I could do the 19th.
Okay, we can do the 19th then. So September 19th at 8:15.
Judge, Mr. Monier, and Mr. Monier has to get another spinal fusion. He has it's a spinal fusion, correct?
Yes.
He has serious back issues. That's happening on August 24th. He's not gonna be able to move, correct?
At least for about 2-3 weeks, but I
2-3 weeks.
under the discretion of the court, I could try to make it here. I'll just be on crutches or walk.
I was gonna say, or alternatively, if we could appear via Zoom, but I'm not sure how the court wants to handle it, because if the sentence is imposed, I don't want to look like we're trying to restrict court imposing a sentence that he would have to remand himself. And I'm not asking for a COGS either, but I do just want to make it known that Mr. Monier, it will be hard for him to appear in person. He can appear via Zoom as well. So, and we're not trying to negate the sentencing or anything.
That's fine. You are welcome to appear by Zoom, either or both of you, if you want to do it that way. If for whatever reason your medical condition prevents you from proceeding any way that day, just contact our office.
I'll know before, and we'll be able to reschedule way before.
Okay.
Thank you, Your Honor.
Thank you, Judge. So we'll be via Zoom, both of us.
Okay.
If that is all right.
Yeah, that would be fine. So, all right. So, Mr. Mooney, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background. Ms. Holly, is it all right to just have him step over to the probation office? Okay. So Mr. Mooney, the probation office is directly across the hall from this courtroom. If you step over there, they'll have an information packet to give you, and they'll collect your contact information so that they can get a hold of you.
Thank you.
Okay. Anything else we need to address today?
Not from the people, Your Honor.
I have a tendered plea agreement form. Would you like me to
Oh,
approach?
sure. If you want to approach, I'll take that.
Thank you, Judge. Well, we don't need a copy, but for his file.
Okay, thank you.
Thank you, Judge. Thank you, Ms. Reynato.
Okay, thank you. Well said.
Thank you, Your Honor.
Have a good one.
All right, I've got one person here. Let me see who it is. All right, Mr. Shelton, can you hear me?
Yes, sir.
Okay, Ms. Underwood, this is Justin Shelton. You need to speak with him.
Yes, Your Honor. Can I go in back?
All right, Mr. Shelton, Ms. Underwood is going to log in on Zoom. If you give us just a minute here, and then I'll have you speak to her in a breakout session.
Okay. Yep, sounds great.
Your Honor, I know I took over for Ms. McClure kind of in the middle of things. Is there anything else that you need us for?
Let me look real quick.
Just want to make sure I'm not missing anything.
Is Miss Underwood in here?
That way she's on Zoom.
No, it looks like we're all set with you, Mr. Bayanetto, as far as I can tell.
Okay, thank you. Have a good day, Judge.
Yep, thanks, you too. Okay, Mr. Shelton, I'm putting you in a breakout session with Ms. Underwood right now.
Okay, sounds great.
You already called Brown.
No, I have not, but I can do that. I think. Probation violation. Like 24 days. Okay, this is file 20-20030-FH, People versus Kyle Leroy Brown. We are here today for a hearing on a request and summons for probation violation. We are proceeding today. The courtroom is open to the public. We're also proceeding by Zoom. The record should reflect that Mr. Brown was ordered to appear here this morning at 8:15 a.m. to respond to the show cause for an alleged violation of probation. Mr. Brown is not present in the courtroom. There is no one present in the courtroom, and Mr. Brown is not logged into the Zoom session. I do not have anyone in the Zoom waiting room at this point. So I'm going to find that he's failed to appear. I'm going to issue a bench warrant for his arrest. I'm going to set bond on that bench warrant in the amount of $50,000.
Thank you.
Okay, and we can do Mr. Rakes as well. We are on the record in files 24-21776-FH and 24-21777-FH, People versus Devin Dean Rakes. We are here today for a hearing on a request and summons for probation violation. We are proceeding today by video conference and also in person. Ms. Underwood, you want to appear for Mr. Rakes on this, or?
Oh, I'm sorry, I was talking to Mr. Shelton. Do we have Mr. Rakes now?
He was set for a probation violation. The allegation is that he was sentenced to jail and required to report to jail, but didn't report, and he's not present here today.
Yes, I will appear.
Okay, go ahead and place your appearance on the record then.
Rhonda Underwood for Mr. Rakes this morning, Your Honor.
All right, and as I just indicated.
I have no knowledge as to his whereabouts.
Okay, this was set for a hearing on an order to show cause. Mr. Rakes was ordered to appear here today to respond to the alleged probation violation. He was sentenced to 9 months in jail on July 11, 2024, and ordered to report on July 16th, on or before July 16th at 5 p.m. The allegation here is that he failed to report to the jail, and so this summons was sent out. He has failed to appear here this morning, either by Zoom or in person. I am going to issue bench warrants for his arrest in each file and set bond on those bench warrants in the amount of $50,000 each file. Okay, so we can go back to Mr. Shelton then. So we are back on the record in file 19-19673-FH People versus Justin Matthew Shelton. And Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Shelton this morning, Your Honor.
All right, and let's see, where do we stand with Mr. Shelton's case today?
Your Honor, this is a violation of one of Mr. Moore's cases, and it's a series of fines and costs. My client is in the process of completing everything he needs to do to get his license that will allow him to, I believe, drive commercially, and he has a job lined up for him as soon as he does that. I'm going to ask, since it is Mr. Moore's case, if we could put this over till the end of next month. My client appeared. He is aware of the situation, Your Honor. He's trying to address it. And if we could just have a little patience and continue the not guilty plea and maybe set this for the end of September.
Just so you know, that case has been reassigned to Jen Walsh, and she looked it up, and there has not been any payment made since March 5th.
I couldn't hear
Ms. Holly, your audio is bad again, and I can't understand what you're saying.
Can you hear me now?
No, it's not really any better.
I don't know why. I'm in chat.
Okay, I believe I heard you say that it was reassigned to Ms. Walsh.
No.
That's fine, Your Honor. We would still like an adjournment till the end of next month. Maybe we can get this matter addressed.
Okay, so all right, so a chat message from Ms. Holly indicates it was
I
reassigned to
got the
Ms.
same
Walsh,
chat, Your Honor.
and it was supposed to be discharged. So it looks like maybe there's a discharge on its way. So, okay, what I'll do is I'll adjourn this to October 2nd at 8:15.
Thank you, Your Honor.
And we'll see if it gets resolved one way or another in that time.
What was the date?
October 2nd. Oh, all All right, so October 2nd at 8:15. Okay, so Mr. Shelton, you can go ahead and log out.
Okay, thank you.
Is that everything, Your Honor?
Yeah, I think that's everything that we need you for, Ms. Underwood.
Thank you.
Okay, so we can do Mitchell Robinson. Okay, so this is file 23-21285-FH, People versus Mitchell Lee Robinson. We're here today for a hearing on a request and summons for probation violation. Record should reflect that Mr. Robinson was ordered to appear this morning at 8:15 a.m. It is now 11:26 a.m. Mr. Robinson has not appeared either by Zoom or in person. I am going to issue a bench warrant for his arrest. I'll set bond on the bench warrant in the amount of $50,000. All right, so this is file 24-51764-PH. Rita Naomi Duff versus Tiffany K. Jensen. We are here today on an order to show cause for alleged violation of a personal protection order. Record should reflect this matter was set for a hearing this morning at 8:15 a.m. It's now 11:28 a.m. Ms. Jensen has not appeared here today. I do not see proof of service indicating that this was served on Ms. Jensen. Also aware that we are in the middle of a hearing on a motion to terminate that personal protection order. And I think it's entirely likely that Ms. Jensen is either confused on the dates or never received notice of this. And so what I'm going to do is adjourn this to August 23rd at 9 a.m., which is the date of the continued motion to terminate the personal protection order. Okay, I think that is everything. All right, so Ms. Holly, I think we are all set for today then. I apologize, I misunderstood what you were saying in your chat message about Mr. Shelton until it was too late.
I know, it's okay.
So, and now I can hear you all right, so.
Oh, fine. It's so frustrating. Thank you.
Okay, thank you, we'll see you later.
Yep.